Broadcast is now starting. All attendees are in listen-only mode.
Hi everyone, and welcome to today's webinar, Doing It Your Way, Thoughts and Issues with Typical Company Formation Structures, presented by Early Growth Financial Services and VLP Law Group. My name is Amanda Young, and I'll be your moderator today from the EGFS team. And I just wanted to give a few quick notes before we get started today. The webinar will last about 60 minutes, including some time at the end for questions and answers. We'll also take some questions if you have any quick questions pertaining to the current slide throughout the presentation. So you can go ahead and type those into your control panel. The next thing to note is that this webinar will be recorded and we'll send it to all the registrants within 48 hours along with the PowerPoint presentation. You can also find this recording and all the recordings from our webinars on our YouTube channel, which is Early Growth. Now, without further ado, I'd like to intro you all to Sirk Roh from the Early Growth team, who is going to tell us a little bit about early growth and himself before kicking it off to David Goldenberg from VLP Law, who will be presenting on this topic today.
Thanks, Amanda. Hello, everyone, and thank you very much for taking time out of, I'm sure, what is our busy schedules for you to join us today. We are Early Growth Financial Services, and thank you very much, Amanda. Early Growth Financial Services is an outsourced accounting firm that helps early stage tech companies as well as other small and medium-sized companies who really either don't want or don't need to be hiring financial and accounting people full-time as internal resources. And so we help smaller and early stage tech companies and assist them as they grow to the point where they obviously need more internal people. We basically provide 5 types of services or 5 platforms. We do transactional accounting or day-to-day, month-to-month bookkeeping and accounting, including doing full closes, GAAP-based closes of accounting and financials. We provide CFO level services, and many times we go in as a team of 2, a senior accountant and a CFO, and we really become the accounting and finance department for our clients. We do tax returns. We do company valuations. So if you're a company that is providing stock options to your employees, you should be valuing the strike price of those common stock on an annual basis at a minimum, and so we provide that service. And we also do fund accounting and administration as well. And you can see the services that are included. But basically, for all intents and purposes, we assist with anything and everything that a small company might need in terms of their accounting support.
Perfect. Okay, so now I'm going to pass it off to David Goldenberg to tell us a little bit about VLP Law and himself, and then we'll go ahead and get started with the presentation.
Great. Good morning, everybody. Hi, my name is David Goldenberg. I'm from VLP Law Group. As the slide shows, VLP is a distributed law firm. We offer a variety of business and transactional services, everything from very early stage startup formation company help to handling work for some of the world's largest companies, Target, etc., HP, Stanford University, all sizes. Our attorneys are all experienced, so you are getting, whoever works on your account has done what they're doing for you at least 5 years, and we are typically much more senior than that. Like myself, I have 20 years experience. My whole team has at least 10. So everyone who touches your account is super experienced. This webinar actually comes from a lot of my personal experiences working with startups over the years, and questions and issues that I have seen in my practice. So these are real world type examples of things that have actually happened, and solutions that we helped our clients get. I personally am a Stanford Law grad and was a general counsel for a few years and have been practicing at VLP for the last 10. people choose us and me and my team for our team with billion-dollar deal experience and focus on legal solutions. Also, I try to give personalized insight to make important decisions and help you achieve your goals. So that's a little bit about VLP and us, and I guess we're going to jump right into it here. So what we're going to be talking about today is how most companies, or a lot of small companies, form nowadays, and some of the potential issues that you may face as a founder of one of those companies, and solutions to those issues. So these are, this may not have happened to you yet, some of these things, but there may be questions you never even thought of or never thought to ask, and you might be quite surprised to hear some of the ways that typical company formation documents treat some of these very important issues. So a lot of what we'll be talking about today are issues between co-founders or between founders and investors. So we're talking about people who have large chunks of the company and significant activities with those key constituencies. Next slide. So companies nowadays can form in all different types of entity types. For the purposes of this webinar today, we're going to assume for all the examples given that you've chosen a corporation. That's certainly the most typical formation type for a venture-backed startup. There's a lot of reasons about that, and there's probably a whole nother webinar we could have about choice of entity. If you chose or choose to be an LLC or a partnership or an S corporation or different types of entities, a lot of these issues will still apply. But in terms of how we're going to be reviewing documents and talking about numbers, everything here today is going to be discussed in terms of a typical C corporation, often set up to receive outside investment. Next slide. So what I'm going to do right now is give you a brief summary of two of the most common ways that we see companies come to us that have formed already. So sometimes founders will call us up and ask us to do the formation for their company, but very often they'll have already used some online service to form their company, assuming that that's, quote unquote, good enough. So a typical, what I'll call basic formation might come from a company like LegalZoom. And they are providing you with a set of documents, typically not prepared by an attorney, and most likely they only take care of filing the most basic documents. So in the case of a corporation, they would file the articles, and then they would send you a package. I have a ton of clients that will call me or start working with us to finish the rest of that formation. That's extremely dangerous. So you may have a handshake with your co-founder and say, okay, we're going to be 50-50 or we're going to be 70-30 or whatever it is that you've decided. And if you've never signed the paperwork, that is really only as good as each of your memories. So I've had clients come to me after there's been a falling out, and so one client who plans to continue with the business remembered that the conversation was that he was going to have 70% and the other co-founder was going to have 30. And of course, the other co-founder who's leaving remembered something different and thinks it was 50-50. Without signed paperwork, there's really no way for anyone to prove anything, and you actually default into perhaps a partnership structure, or depending on what the communication was between the parties. Anyways, that's the typical basic formation document. Very typically, even if you do fill out all the paperwork, a LegalZoom type document will not have any concept of vesting, so that both co-founders would be fully vested on day one, and no discussion typically of assignment of any prior created work. So very often companies will work on a project for a while before deciding to incorporate. They may need to incorporate before getting their first customer, or to sign up for a particular service, but they may have been working on the product for a year. And if that prior work isn't properly assigned to the company, you have a big gap, the company does, in the ownership of the work that's been created. So without proper assignment there, again, even if you have everything else done correctly, that co-founder could leave and claim that they own, a big chunk of the code because it was never assigned to the company, creating, again, further problems for the company down the road. So that's the sort of first version.
Yeah, and also just keep in mind that as you look forward, right? So as David just mentioned, when you're first starting up a company, you may not foresee some of these situations coming up, but even in the best case scenario, and you don't run into any of these problems, to the extent that later on you're going to be going out and looking for investment, outside investors, right? All of this is going to have to be in place. It's going to have to be documented properly. Without proper documentation, without proper paperwork, without really solid legal backing, is going to be it's going to be very, very difficult for you from a fundraising perspective, and things are going to have to be redone correctly when that happens in any case. So it really critical to do things right from the very, very beginning, as David mentioned.
Absolutely, couldn't agree more. All right, next slide. So the next the next type of company I want to cover is a startup itself, which is in the sort of legal software space. They're called Clerky, and we are seeing more and more clients come to us with the formation done by Clerky. Clerky's certainly better than LegalZoom if you're starting a technology startup type company. They do also prepare the basic documents. They do give you some help, and I think even potentially access to an attorney for up to an hour or some short period of time, which is great. They also allow for some customization of the documents. There are typically set up so that you default into a vesting schedule, which is, I think, generally recommended. Although not something you don't get really counseling about that. You just sort of get defaulted into what is the typical vesting here in Silicon Valley, a 4-year vest with a 1-year cliff. What that means for those of you who don't know what a cliff is or 4-year vesting is, what that means would be if you started at the company today, you would own all of your stock, but the company would have the right, if you ever left the company for any reason, to buy back a portion of the stock at the original price. So if you typically would pay something like $100 for your founder shares, the company could buy on day one all of your shares back by just cutting you back the $100 check. The vesting period is the time upon which that right lapses. So let's say in 1 year, the company couldn't buy back all of your stock. They could buy back 3/4 of it because you're on a 4-year vest. And they would give you a check for $75, and your stock would then go back to the company, and you'd keep 1/4 of it, and so on and so forth. After 2 years, you could keep half, and they could buy back half. The cliff refers to the fact that you don't get any of your stock for the first year. So it takes a full 365 days for you to get any stock. After that, typically you would get 1/48, which is 1/4 years of the stock each month. So if you left in, let's say, 1.5 years, you don't have to wait all the way till year 2 to get any more stock, but you do have to wait all the way through year 1. So that's a typical Clerky formation. As I said, it's better than the basics for tech startup companies. It doesn't deal with, as it mentions here on the slide, the agreements between the founders, which is a lot of what we're going to be talking about today. And if you guys have questions about either LegalZoom or Clerky, I'm happy to talk through all that at the end. So why don't we go to the next slide here? Okay, so one of the issues that neither of these services helps you with, and is probably one of the most important issues that a startup will face, is how do you decide between you and your co-founder how you're going to split your stock. So as you can guess, a lot of people will come in and default to 50-50. Let's say if there's two founders. We can see that on the next slide. So many startups default, as the slide shows, to this 1/n. So if there's three founders, it's a third, a third, a third, or if there's two founders, it's 50-50. That really does not recognize the potentially, people's contribution to the company, what is fair. Sometimes someone is putting up money and others are not. Sometimes someone is quitting their job first and working full time and others are not. Sometimes someone is much more experienced and the others are less experienced. So one of the things I would encourage is, and I think that might be on the next slide here. Let's see. Oh no, so we'll go back. So one of the things I might encourage is for you to look at, there's lots of information out there on how to pick better than the sort of default of 50-50 for your shares. What'll happen is, and there's a professor at Harvard, this guy Noam Wasserman, who actually studied 10,000 companies and did a report. And he's written a book and done TED Talks, and it's very famous. And there's lots of information just by him out there. His study, the book I think ended up being called The Founder's Dilemma. But what he does is he goes through and he studies and does case studies of specific companies. And what will happen is, if you have one of these disparities, after a very short period of time, because you didn't want to have that hard conversation up front, the founder, let's say, who's contributing more, feels like it's an unfair deal. That person will then withdraw, as opposed to trying to make the other person contribute more. They'll just start contributing less, and the startup suffers. A lot of times the company may die just from that alone. If people aren't giving 110%, it's very hard to make it in the startup space. So it's a hard conversation, but one that you should probably have up front. So that's kind of homework for all of you guys. To do that, we can of course help counsel you on the interpersonal, particular nature of your startup, and to give you guidelines and estimates and typical numbers for what someone might get if they, for instance, put up money versus more time. But ultimately, the decision is one between you and your co-founders. And honestly, it is, as I mentioned before, one of the most important decisions in your whole company's life.
And just piggyback on that too, and that's another reason why you might want to work with an experienced attorney early on, right? Because now what you've done is you've brought in someone from the outside, someone who's objective, right? Someone who can give counsel based on his or her experience with lots of startups, with lots of founders who've gone through the same situation as you, instead of two founders really hashing it out and trying to figure out, what should take precedence in terms of priorities, in terms of who gets how much. Sitting down as a pair of founders or three founders, sitting down with an attorney who can kind of give some counsel and some guidelines to think through would make it a little bit easier to have that hard discussion, as opposed to just hashing it out and saying, picking your corner and coming out fighting and trying to get as much as you can.
Absolutely, yeah, and a lot of times it is that neutral voice that can help solve some of those problems, or even just help you guys talk about it in a productive way. All right, so let's talk about, so you've gotten through it, and you most likely have chosen, let's say, 50-50, or if you have four founders, 25% each. Let's look at some of the problems that get created that, again, neither of these online services really deal with, and could become significant issues for you and your company and the co-founders. So the first one here is deadlock, right? So deadlock is it's probably a term of art. I don't think it could be a legal term. But what it really results, I think everyone understands the concept, which is if there's two of you and one of you wants to, let's say, open an office in San Francisco and the other does not, how do you decide if that happens or not? if you've defaulted into a company with exactly 50-50 ownership and both of you on the board, what that means is that the company, the person who doesn't want to do something, because most things require approval, approvals typically require a majority. And so the person who doesn't want to do the thing will win. And that doesn't mean it's the better idea. It just means it's the way that the law is set up. It favors inaction when there's deadlock over action. And honestly, the solution is not one that I think most people would prefer, but it's to dissolve the company. If you're intractably deadlocked for a certain period of time, you know, eventually what happens is you guys split the company. And in most startup instances, especially pre-funded startups, that really means the company dies. You can't force the other person to give up their share. You can't force the person to give you control. You can't force the person to give you the code or do anything. And so you can sit there forever, and they, you know, can literally kill the company if that's what they want to do. You can also quit, of course, yourself and move on. But again, your ability to start a similar company might be hampered by the fact that this other company either owns a lot of code that you spent writing or owns the ideas that you guys have come up with together. And you really can't take that and go start a competing entity without incurring, you know, some significant risk. So one of the issues, again, and this probably, unlike the split piece, which is really a numbers discussion that I think most people, even without a legal education, could figure out, the deadlock piece is typically one that would require an attorney to help you figure out. So there are various mechanisms to resolve deadlock, and you know, an experienced attorney can give you counsel and help you guys as founders to make a decision in order to have a solution for when that time comes. And I'll tell you, you know, speaking from experience and having watched this over and over, the time you want to decide these types of issues is in the beginning. When you come to a deadlock, everyone is aware of what's at stake, and no one will want to agree to anything that would basically let the other side win. And so it's almost impossible to resolve the deadlock once the deadlock activity has occurred. But if you both agreed up front, here's what we're going to do if we can't agree on something, then when that time comes, you have an agreed upon solution. People take out that old agreement and they say, this is what we agreed to before. And, you know, most people have to live by that contract and, you know, agree to live by that contract. And it lets the company survive as opposed to becoming paralyzed and, you know, potentially dying. So, so that's deadlock. The next issue is related to deadlock, which is, and something that I think a lot of founders don't think about. So again, assuming you started a 50-50 company, and you could each have, let's say, 5 million shares, you know, a ton of stock in the company, and with it, so there's a total of 10 million. You hire your first engineer. The engineer gets, let's say, a very small amount, let's say 10,000 shares. Compared to your 10 million, you know, it's less than 1%. But again, the way that Delaware law certainly and California law very often is written is that the majority, as I mentioned, can take action. And so now if you get in a fight with your co-founder, even though you have, let's say, 49.9% of the company, your co-founder plus the engineer can vote you off the board because they have a majority, can fire you from the company, can make the decision. So again, let's say going back to the should we open the office or not, that person, the small shareholder, becomes the deciding vote. I don't think that's what either founder would want if they were asked up front. And again, it's just a problem with people thinking that if they did it themselves, what could go wrong? Well, these are the kinds of things that can go wrong. So, it's something to think about. Again, it's something to plan for. And again, there's very simple solutions that an attorney can help you with. to prevent this type of problem from occurring. So let's look at the next one. Right. So this is basically the summary of what I just mentioned. Right. So the company forms with two founders with 5 million shares. Here, the engineer gets 1%, which is 100,000 shares. And as I mentioned, one founder and that engineer can replace the other founder, remove that founder from the board, fire that person, and stop your vesting if you had vesting in your stock. So you could find yourself frozen out of your own company after 1, 2, 3 years of work with little or no recourse. And if you think that's not fair, if you think that's not legal, whatever, it really at that point there's very little you as the frozen out founder can do. And then the co-founder can then go on with the engineer to do, again, sort of mostly whatever they want from then on forward, as long as they have continue to have a majority of the shares. Okay, so now we'll look at the next issue here. So redemption. So redemption, as I mentioned before when we talked about vesting, so the way that founder stock will typically work, unlike a stock option, so when you get a stock option in a company, if you're working for a larger company, you might get a stock option. The stock option is a contract right to buy some stock. And it may say, for instance, you have the right to buy 100,000 shares, vesting over 4 years, which would mean in that case, you start off with the ability to buy 0 shares, and in 1 year you could buy 25,000, in 2 years you could buy 50,000, in 3 years you could buy 75,000. But you have to then do something further, which is buy the stock. So that's how stock options work. You start off not owning anything and buying into your vested shares. If you quit, you have some period of time where you can buy your vested shares, but you can never buy the unvested portion. So that's how stock options work. In a sort of somewhat not intuitive way, founder shares work very differently. You will start off with your full amount of shares, and that's done mostly for tax reasons. So you buy, again, let's say using the same example of the two founders, on day one you buy all 5 million shares, and maybe you'll pay $100 or $500 for it, and then as I mentioned before, the company has a right to buy all those shares back for the price you paid, and that's what's typically called redemption, right? So when the company buys back its own stock, that's called a redemption of stock, and so that all makes sense, but it has a very different effect on your cap table. And so what we're going to look here is what really happens when you have someone leave after, let's say, 1 year. So we'll start and we'll look at an example. Okay, so same company, two founders. They get 5 million shares each, 10 million shares total. 1 year in, things are not working out, but it's just after your cliff. Or a lot of times, even if it's before your cliff, in order to make things feel good for everybody, you agree to give that person, let's say, their cliff vesting. Founder 2 resigns, and the company would buy back the 3/4 of the shares that are unvested, and the founder would be left with the 1/4, which in this case is 1,250,000 shares. The other shares are redeemed. And this, again, I've had founders call me, scratching their heads, not really understanding, because this concept of the stock issuance is not really intuitive. People think, I've issued all 10 million shares. How do I get more shares? Well, the company can always issue more. And the same way, when it redeems shares, the shares come off the cap table. And really what matters is your percentage of the total shares outstanding. So you'll see here in the math below that you may think that your co-founder is going to end up with 1 million shares basically out of 10, and that you could live with the fact that if they only worked for a year, they would get something like 10% of the company, and that feels okay to you. But what actually happens is, because the rest of those shares are redeemed, after the redemption, there's only 6,250,000 shares outstanding, of which your co-founder has 1,250,000, which is 20% of the company. And when founders find out that, and this is even using, Clerky or any of these services, that you think you've got vesting and so you're covered, but you may not want your co-founder to have 20% of the company for just working for the company for a year. And you've got to then move forward and drive the company for the rest of the history of the company, and they go along for the ride basically with 20%. 20% is a huge stake to give to someone for 1 year of work, typically at a startup. So, and I think if you'd ask the founders up front, hey, how much stock do you want your co-founder to have if they leave after a year and a day? I don't think a lot of people would say 20%. But that's what happens when you use the sort of out-of-the-box solution and don't go through a good process up front in order to figure some of these issues out. So I'm going to just pause here and make sure, because this is a little bit complicated, if anyone has any questions.
And David, actually, I know we're going to talk about solutions a little bit later, but probably at a high level. And so what would you do? Like, what would you personally do and advise and try to set up for, to make sure that this doesn't happen?
Well, so the first thing is that you have a good hard conversation with the founders about vesting. And it may not be that the default for your vesting with a 1-year cliff is what the founders want. So we've done longer cliff in periods. So it could be 2 years before they cliff. And then you think, okay, well, if I've made it 2 years with my co-founder, it's probably going to work out. A year seems like a long time, but there's lots of reasons why a startup could go sideways for a period. And, you could be a year in on the numbers, but because you were working part-time or because there was some delay about something, you really haven't progressed very far after a year. So again, depending on the company, a year may or may not be the right cliff period. Other, things that we can help with is putting agreements between the founders about some of these issues very specifically. So, if I leave after a year, but I am, if I quit, we want one thing to happen. If you terminate me, maybe I do get my stock, and that's a little bit of a way to encourage both founders, to stick with it. So that's another option. We could have agreements between the founders about, well, if the investors come in and they want this number to be lower, which is very often the case, and we'll talk about that in a few slides, that I'll agree to give up more of my stock or sell you my co-founder my stock. So those are some of the ways that you can solve this.
Mm-hmm.
Assuming no questions, then we'll just move on to the next.
Yeah, no questions yet, so I'll go to the next one.
Great. Yep. Okay. So I want to explain, the same issue. Now you've got investors, and what happens. So a lot of clients will come to us early on with seed financing in place. Maybe they'll sell 10 or 20% of the company to some initial investors. In order to raise some initial capital, get things going. And so let's say that same thing happens. We'll look at here at the next slide. So same exact company, 2 co-founders, 5 million shares each. And let's say they sold 25% to the investors, so it's another 3 million. So on day 1 here, you have 13 million shares outstanding, as you see in the cap table post-financing, the top part here. Now the founder leaves after they've cliffed, but just after a year, and we have the same problem where that co-founder who's leaving, has more stock maybe than you would want them to have, but the thing to look at for this slide is the investors who didn't do anything, right? They bought 25% of the company. Now the co-founder is left. If you look at the numbers below, magically they've gone up to 35% of the company without doing anything. And in fact, the co-founder has left. So, arguably there's like, you're going to have to replace that person. Again, this is something that I think a lot of founders don't think about upfront, and are sort of unhappy to hear that that's the way it happens. This is certainly the way the investors design the companies to be set up. So if you look at standard venture capital documents, standard seed financing documents, things you may find on the internet, this is how it all works. Typically with founder stock, the investors are looking for ways to get more percentage of the company down the road, and this is an easy one for them. Again, if you don't want this to happen, you need to negotiate that upfront early and have solutions so that if the stock is coming off the cap table, what happens after is something that works for you as a founder. Again, not intuitive, right? Because the way that the stock works, people don't really realize that when the stock gets redeemed, there's a smaller denominator for everyone's percentage. And so the investors, you can't lock people's percentages, but you can take other actions to help balance out some of these effects. All right, so let's talk a little bit about this drag, right? So a lot of times, and I tell my co-founders when we work with companies from the beginning that, like a marriage, a lot of companies do end in divorce. It's not uncommon. I don't know if it's 50%, but it's certainly north of 10. 20, 30% of the companies that I see, there's some kind of dramatic effect in the first 5 years where a co-founder will leave for one reason or another. It may or may not be because things didn't work out. Someone could get married or get a incredible job offer, or the company is just not moving fast enough for them, or there are personality conflicts, or they don't like the direction of the company, and so there are actual business reasons why they're sort of not wanting to be involved anymore. When that happens, that's fine. Again, going back to the example 2 slides ago, your co-founder now has 20% of the company. When you go to an investor, most savvy investors will want to see that co-founder's number, which I mentioned here, a lot of investors call dead weight, right? Dead weight are people who are on your cap table who are not contributing. And so there's reasons, to have given stock to people in the past, but you want to try to keep that number in a small, in the single digits is how the investors refer to that. That is less than 10%, because there's only so many percent to go around, and the investors know that it will probably take 2 or 3 rounds of financing for the company to make it to an exit event, and that means dilution of, let's say, 30 to 50%, 2 to 3 times. If you have a lot of dead weight on your cap table, the founders, the ones who are still contributing, their percentage, because the investor percentage is not adjustable, the investors are going to get a percentage of the company based on what the company's worth at the time they invest. So the only other party really is the founders. And if your dead weight, that is ex-co-founder, has too much of the company, you, the working co-founder, get to a point where you're saying, why am I doing this? If you're founding the company, running the company, working 100 hours a week for years on end, and you've only got a 10% stake in the entity, that may be not enough for you to wake up in the morning, to be energized. And so they want as much of the stock as possible available for the working co-founder, which means, again, that the exited co-founder should have a smaller amount than would happen if you use these default documents without any discussion. So that's, again, another issue. And if the co-founder is not agreeable and they have 20% and they don't agree to give it up, the investor might pass, might very well say, come back to us when you fix this problem. And if you can't fix the problem, they don't invest. And if they don't invest, your company doesn't make it. I mean, to be quite honest, that's what happens. So these are, they're not little issues. They're not things to be brushed under the rug. These are, potentially sort of, company ending situations. So let's talk about solutions, as Sirk mentioned before, right? This is a great picture, by the way. I love. All right, so let's talk about solutions for deadlock, right? So the first one we talked about was deadlock. You've got two founders, you and your co-founder, and you have problems agreeing on things. You can set up in advance a voting agreement that talks about, what you're going to agree to and what you're going to let one person handle by themselves, and what you're going to require both of you to agree on. It can't solve every problem. We can't predict the future of every single situation, but over time, over the 20 years I've been practicing, I see the same types of issues come up over and over again, and those are the ones we try to address. Who decides if you get to sell the company? Again, going back to that solution, the issue number 2, you'll remember that the one co-founder and the engineer who has 1% of the company can literally decide to sell the company over the other co-founder's objection, regardless of the terms, regardless of a lot of things. So you may want an agreement between the two of you that would say, for instance, hey, we need both of us to agree to sell the company, regardless of who else is involved and what other people have to agree. You and I, you, Mr. Co-founder, and I have to be on the same page. As I mentioned a little bit before, on the redemption issue, you can have an agreement between the co-founders that puts those shares in the other co-founder's hands. It's not very common, but it does solve that problem. And I think it's not very common, to be quite honest, because the investors, would rather see the stock go into their hands, as I showed in the other slide. But it's something that you can control if you want to. And then, as I mentioned, the third bullet is the one I was just talking about, right? So not just selling the company, but there may be other significant decisions you want to make sure you and your co-founder agree upon, especially at the early stage where funds are tight. There may be a lot of things that you guys want to be on the same page about, so that you don't feel like your co-founder is mismanaging the company. All of these things are in sort of high generalities. All of them really need to be discussed in a sort of good, honest conversation, typically with, good experienced counsel, to help you try to figure out what's the best solution for your company, right? A lot of people, think that the out-of-the-box solution is good enough, but if you think about how much time and effort you're putting into this company and how much you hope it to be worth one day, a little bit of effort on the front end to make sure that you're set up for success and don't have potential landmines planted in your whole corporate structure, I would certainly think is a good idea.
Yeah, and also, if you think about just kind of the ounce of prevention and all that stuff, but as you look forward to investors, right, think about not only what you're doing today and not only how you're starting up and the ease of that or the difficulty of that, because obviously this is, these are some issues that can be a little bit, sticky, right? But think about in the future, think about when you go after investors and you look for that first round of financing, any of these issues that David has highlighted are going to blow up into huge issues, right? I've seen deals go south where investors are excited. They see a pitch, they like they like the idea, they like the market space, they like the potential, and they obviously like the founders, and they want to take the next step, right? And then as they do their due diligence, they start seeing some of this stuff, right? Some of the stuff underneath that they didn't see initially. Issues with previous founders having too much stock, the dead weight, as David mentioned, or other advisors who have more stock than an investor might think that they should have. These are things that can and will kill deals, kill financings. Because if you think about it from an investor standpoint, right, they're looking at lots of different investment opportunities, and a lot of times while they want to invest in the company, they're looking for reasons. They're looking for reasons to say no, because they have so many opportunities, and they're looking for kind of that perfect opportunity. And when they see issues like this on the cap table, or agreements, or lack of agreements that have caused problems early on in the life of a company, they will absolutely take that as a reason, as a good enough reason, even though they like the idea of saying no to an investment opportunity. So there's lots of landmines here. I think that David, I mean, just listening to the presentation, you can tell that there are lots of pitfalls that you can run into here. The real key is just to kind of do things right from the very, very beginning. You as a founder, haven't seen, all of these situations. You're probably not even aware of a lot of these situations. David is. We certainly see it at Early Growth. We see it on the finance and accounting side. Similar types of situations where we get, after the fact, we see companies that need their finances and accounting fixed, and it's usually a much bigger job to try to fix it after the fact than it would have been if we did it right from the very, very beginning. So that's kind of the big takeaway, as far as I'm concerned, is just to, it's a very, very tough thing that you're doing. You need to focus on getting the company going and being as successful as possible. Having these kinds of headaches and pitfalls throughout the life is really going to be huge setbacks.
Great. Well, I think thanks for that, Sirk. And I again agree 100%. That's why I'm here, and thought this would be good for your people to hear. I think that's the end here. If you guys have questions, now is the time. Or if not, my email is up there, and you feel free to email me at any time.
We do have one question right now from Noah, and he was asking, if you have formed your company with Clerky, what else is needed in addition between the co-founders to do after that?
Right. So again, I think that would really depend on some of the on your particular company's setup. So if you have two co-founders, and you form with Clerky, you have and you're both on the board, and you both have the same amount of stock. You have the deadlock issues that I mentioned above. You have the redemption issues that I mentioned in the talk. And if you don't like those, the way those work out, you need to call an attorney and have that attorney help you figure out a solution that's going to work better for you. So either a co-founders agreement, a shareholders agreement, a voting agreement, or all of the above.
Great, thank you. So we have one more question from Renata. She would like to know, what if founders set up using a basic formation service and did not know to purchase founders stock in the first year?
Right. So we deal with that all the time. That really is so we can help fix that. It happens a lot, and you kind of have to look at all the facts. So if the company, for instance, is still pretty much in setup mode, then the solutions are relatively easy. We just go back and maybe you can issue the stock now. If the company is already having customers, or value has been created, then some of the solutions can be, you can still solve the problem. It tends to get more difficult as the stock. You can't say the company's only worth $100 now, because there's real value inside it. So, but we can figure out solutions. Again, we'd have to look at the particulars of that particular company. But you can't just go back and buy your stock for $100 now. I'll tell you that. Again, if value has been created.
And don't wait, as David mentioned. So if you have done work, if value of the company has increased by any objective manner, the longer you wait, the worse it is, right? So if this is the situation you're in, then we highly encourage you to reach out and get assistance and counsel as soon as you can.
Okay, a couple more questions. Greg would like to know, would you not recommend forming an LLC strictly online on your own for your own individual company?
Again, hard to give legal advice in the abstract here. A single member LLC, from a tax perspective, so a lot of the problems with LLCs that we see are that the agreements that people pull from some online service really don't match what they want. And even more so than a corporation, where everyone sort of understands what a share of stock is, because that structure has been around so long. Unlike that, an LLC is a relatively new structure with pretty complicated terms in the agreement, because everything really needs to be spelled out. If it's just you and there's no other people involved in the entity, a lot of those things don't matter. So it could be that an online service for a single person doing their own LLC could work. Again, the only way to know is to look at the paperwork used by that service and to talk through with the founder if it works for them. But I wouldn't, categorically say something is good or bad, unfortunately.
That sounds like a question, from the Trump Tax Act that was just passed.
Right. Yeah, I'm sure. Well, yeah, that's right. There are, and some of those benefits, again, are may or may not be as beneficial as they make it sound on TV.
Right. Exactly.
Yeah, next question is, have you found investors amenable to redemptions of unvested co-founder stock going to remaining founders?
Yeah, we've negotiated that for sure. Again, you kind of have to explain why. I think investors tend to be more amenable to solutions that, it's not like, so why should you, co-founder who's staying, have twice as much stock for doing the same job, right? The investor may or may not agree with that concept, but they may agree with, if you find a new co-founder, we'll let that stock go to that co-founder. And again, that has to be drafted up front, because otherwise the investor will sort of, it's at their whim if they decide to agree with you or not, unless you've agreed up front about that. But yes, we've solved that problem vis-a-vis, co-founders and investors. And not every investor, not every situation, but it can happen.
And to David's point, you want to do that up front, right? Because it's going to be very, very difficult after the fact. If you don't have an agreement like that in place, it's going to be very, very difficult to get the investors to agree to take those take those shares and either give them to yourself or to new partners or new people that you're going to be hiring. Because basically, without that, the investors are going to get more of the company, right? If they think that you're still going to be successful, if the company's still going to be successful by having those shares redeemed, they're much better off. So again, thinking about that in advance, thinking about that possibility, putting it in the paperwork on the front end is going to be what's going to keep you is going to allow you to keep those shares or to keep those shares within the company and not redeemed. And
thanks, Sirk. Next question is, assuming one co-founder has majority stock and both co-founders have a 1-year vesting, what happens if one co-founder is not performing? Can the majority co-founder remove the other co-founder, or do you need to have an additional co-founders agreement beyond just a distribution?
Can you read that question again?
Yeah. Assuming one co-founder has majority stock and both co-founders have a 1-year vesting. What happens if one co-founder is not performing? Can the majority co-founder remove the other one, or do you need to have an additional co-founder agreement beyond just a distribution of stock?
Okay, well, it'll depend on what the vesting says, is the first thought, right? So sometimes, as I mentioned before, the vesting is written so that different types of terminations result in different types of vesting. But assuming, and then the second issue is, how do you remove that person, right? So if the person doesn't want to quit, the shareholders don't control who works for the company. The board typically does. And so if you don't control the board, if both co-founders are on the board, even though you have a majority of the stock, you may or may not be able to replace that other person on the board. And that, again, we'll look at what the issue is, and if it's complicated. I guess it would be better to be solved up front. It could be that the majority co-founder could sort of weave a path to removing the other co-founder, but it might not. It's not a slam dunk. I'll put it that way.
Thank you. Okay, so here's the last question. How difficult and costly is it to reincorporate?
If you're moving from California to Delaware, and everything is the same, not that bad. It will depend on how complex the company is at the time that they want to reincorporate. So if it's just a few co-founders, then that's not that much paperwork. If you've grown and there's 20 people on the cap table, all of those people sort of need to get converted into the new company. It also depends on going from what state to what state, if that's the purpose of reincorporation. Every state has different laws. So sometimes it's a simple process, sometimes it's a complicated process, depending on how those two states interact. If you're reincorporating for another purpose, like our cap table is messed up and we want to, get this person off the cap table, that can be a much more involved process, because you really have to consider that person might object to you sort of, doing that, right? You're taking action really to disenfranchise them, and they may have recourse and rights, and so you have to really consider that at every step of the way. So that can be a very complicated, job.
I'm wondering, Amanda, if the question was regarding like just a reincorporation under the same type of entity, or if the question might have to do with things like going from an LLC to a C corp, or different types of entities, and how that changes the equation.
Yeah, I'm not sure because he didn't clarify. But it looks like we're about hitting time here and we don't have any more questions. So everybody feel free to reach out to either David or to Early Growth. If you have any other questions, I'll also be sending a follow-up email later today, so you can feel free to reply to me as well, and I can help direct your question. Any closing thoughts before we say goodbye to everybody, David and Sirk?
I just wanted to thank everyone for their time again, and if you're a founder at a startup, or if you're a part of a founding team at a startup, I wish you the best of success. You're doing God's work out there, making the world a better place to live.
Nice of you to say. That's good advice. All right, thanks everybody, and good luck. And if you have questions, again, I'm around.
Thanks everybody.